committee will come out of recess, and we're going to open the public hearing on Senate Bill 507 and recognize prime sponsor, Senator Whitley. Good afternoon, Senator.
Good afternoon, Madam Chair, and hello, members of the committee. For the record, my name is Becky Whitley, and I am honored to represent Senate District 15, which includes the wonderful communities of Bow, Concord, Pennacook, and Hopkinton.
Oh, somebody's phone is going. Thank you.
Today, I'm honored to introduce Senate Bill 507. This is a bill I believe is necessary to ensure that justice prevails in the Granite State. So this bill deals with the post-conviction process and extends the time to petition a court for a new trial in certain cases. As a quick refresher, the post-conviction process is in place to both protect innocent and guilty individuals from inherent human error in the criminal justice system. Unfortunately, we know that there are still innocent people who are convicted of crimes and spend years in prison while the real offender remains free in our communities. Although it is still exceedingly difficult to overcome a conviction, even for an innocent individual, convictions are being overturned around the country and individuals are being exonerated with increasing frequency. In post-conviction cases, an exoneration, another sort of refresher, an exoneration may occur when a person who has been convicted of a crime is officially cleared based on new evidence of innocence. This can occur through a pardon based on actual innocence and acquittal at retrial, or a conviction being vacated or indictment dismissed. As we all know, the use of DNA testing has been used to include or eliminate suspects in our criminal justice system, and of course now is being used to exonerate those convicted of serious crimes. In New Hampshire, there's been only 3 exonerations, and I think it's important to note that this low number is low compared to the rest of the country, and this is despite the fact that DNA testing has been available since the 1980s. So although we wish, of course, that the criminal justice system was perfect, data does suggest that the more likely reason for this low number in New Hampshire is that we're just not discovering those wrongful convictions. One of the bars to discovery of these wrongful convictions in New Hampshire is our outdated statute. And it's outdated because it provides only 3 years to overturn a conviction. This timeline is very much out of step with the rest of the country. New Hampshire is only one of 6 states with this absolute timeline, meaning there's an absolute timeline of 3 years. And, this is not consistent with changes in forensic science, new investigative leads, new scientific techniques or procedure, or of course, just newly discovered or better understood evidence. I think the point of this bill is that science is constantly changing and we have to be able to accommodate this growth. I wanted to point out that not only is New Hampshire out of step with the rest of the country, again, we're only one of 6 states that has absolute timelines, we're also out of step with what is recommended by the American Bar Association. The American Bar Association, a standard on post-conviction statute of limitations, states that, and this is a quote from the American Bar Association, a specific time period as a statute of limitations to bar post-conviction review of criminal convictions is unsound. So basically they're saying that our current statute with our absolute timeline is just unsound. Conviction finality is meaningless, of course, where the conviction was wrongful. I think there can be little comfort to our victims in convicting the wrong person. I want to provide an example to illustrate why this bill is so important. And this is a case that happened out of Massachusetts. A man named Gary Civisari was convicted of a brutal assault and murder in Massachusetts in 1983. His innocence was not litigated until 2017, 34 years later, of course, well after the statute would have run. Gary's exoneration began with the discovery that bite mark science was not what forensic odontologists had believed to be at the time of trial. Because the Massachusetts statute accommodates changes in science and its statute of limitation, Gary's case was able to be litigated and Gary was exonerated. This would not have been able to happen in New Hampshire under our current statute. Thank you very much for your consideration of this bill. I will note that I am not a practitioner in this area, but there are practitioners behind me if there's any more detailed questions about how these cases actually work. Thank you very much.
Thank you very much, Senator. Are there any questions for Senator Whitley? Seeing none, thank you very much,
Thank you.
Senator. Okay, the chair will call Cynthia, is it Mawson?
Musso.
Musso,
A lot
okay.
of vowels. My name is Cynthia Musso. I'm a staff attorney with the New England Innocence Project. The New England Innocence Project, for those folks not familiar with us, is an organization that works to prevent and correct wrongful convictions in the 6 New England states. Before I joined NEEP, I was a public defender in New Hampshire, and I am the only staff attorney at NEEP with any experience litigating in New Hampshire. I'm also the only attorney working full-time on post-conviction innocence litigation in this state at all. So I say all of this to say that I am sort of uniquely in a position of understanding exactly how the statute of limitations in the state will impact wrongful conviction litigation in New Hampshire, and how the changes that we're requesting today would not only help free the innocent, but would also improve New Hampshire's criminal legal system as a whole. So as discussed by Senator Whitley, the current version of the statute has an absolute bar of 3 years from the rendition of judgment. This time is virtually impossible to meet in wrongful conviction cases. In 2016, the National Registry for Exonerations reported that an average exoneration took 11 years, which is almost 3 times the amount of New Hampshire's limit. Wrongful conviction work is very slow for a lot of reasons. It's hard to find case documents years after cases are closed, witnesses die, and scientific understanding of evidence changes. As just one example, I have been working on a case since 2022 in this state. The case dates back to 1988. The Attorney General's office just located a box of evidence in this case just this past month. It took them years to find just this one box of evidence. In New Hampshire, where there are only 3 exonerations, as Senator Whitley mentioned, there's only one attorney looking for these cases full-time. This 3-year time limitation is preventing viable claims of innocence from coming to light. The current statute also doesn't account for changes in science. So many scientific theories that were once considered rock solid had been disproven over the years. As we've heard about bite mark evidence. This was something since 1954 that people thought was inherently true, that you could determine whether a mark on flesh was a mark made by teeth. And experts claimed they could match these up with people's dental records. It wasn't until 2009 when the National Academy of Sciences concluded that forensic odontology had, quote, no meaningful scientific validation, that people began to question this use of science, in quotes, in the courtroom. For anyone convicted on the basis of bite mark evidence in New Hampshire from 1954 to 2006, this new scientific development could not help us obtain a new trial under the current version of this statute. And specifically, Gary would have been out of luck if his case was out of New Hampshire. And bite marks aren't the only questionable forensic science that's been accepted in courtrooms across the state. Other methodologies and technologies like hair comparisons, bloodstain pattern analysis, all have been subjected to significant scientific doubt in the relevant forensic communities. Not only discredited science, but advancement in science too can lead to exonerations. DNA made its first appearance, as Senator Whitley pointed out, in 1988, and since that time, DNA has become even more exacting and requires even less biological material to generate a DNA profile. In other words, testing has become easier and more accessible, and also has changed. These changes have made it more applicable and accessible in a number of cases, and this 3-year statute of limitation would prevent some of these cases where DNA testing was in 1988 not possible, from now being possible, from shedding light on these innocence cases that we could have in New Hampshire. As Senator Whitley pointed out, we're very out of line with the rest of the community, with the rest of the country. In fact, 32 states have no time bar at all on statute of limitations for motions for new trial. Only 6, as Senator Whitley stated, have bars in New Hampshire. 0, there are no New England states besides New Hampshire that have a time bar. That have an absolute time bar the way New Hampshire does. With the proposed changes to the statute, New Hampshire can bring itself in line with the rest of the country and with scientific understanding. There is no value in a wrongful conviction based on false or misleading evidence, and this bill would offer a meaningful pathway to correct these wrongful convictions in New Hampshire. I appreciate your time, and if anybody has questions, I'm happy to answer them.
Thank you very much for your testimony, Ms. Mosso. Are there any questions of Senator Chandler and then Senator Gannon?
Thank you. I'm not sure that you can answer this question, and Senator Whitley said our law was antiquated, but how long has the 3-year bar been in place?
I don't know when the statute first was originated. I know that we haven't had a NEEP lawyer in New Hampshire ever until 2019 because that's when I started. So I only know as far as that. I don't know how old 526 is.
Thank you.
It should be somewhere. That should be, I'm not sure.
Okay, Senator Gannon?
So if we have one innocent man get off, which is probably one of your slogans, right? That's worth all the effort. How much, and you've got 3 off. Have you put how much effort and time and money and expense? How many are you working on this?
Oh my gosh. So we have thousands of applicants to the New England Innocence Project, but that's across the 6 states. I would say, so I'm primarily working on New Hampshire cases. What happens is I have an active caseload, and then we have caseloads that are waiting in the wings to be called up when my active caseload is complete. So I have probably 20 cases that are on my active caseload currently, and then there's probably up to 100 that are sitting in queue for us right now, waiting to be assessed in New Hampshire.
So brief follow-up.
Yeah.
Okay. So just so I understand this better, so everybody in jail, right, usually would say that I'm innocent, right? How do you weed through? You go through and you look for probable cause that there may be some valid
So
stuff to the
I make 2 points to that. The first is that as a public defender for years and years and years, I actually don't think a lot of people claim factual innocence.
Okay.
I think the reality is that a lot of people feel that they are wronged for being in prison, but don't actually claim that they didn't do the offense that they're charged with. Most folks, when they claim innocence, that's a much smaller number. If we're assuming that the 120 folks that have applied to me is the selection of folks that are in prison that have requested this, that's actually a very small fraction of the prison population to begin with. And we do screen a lot of those cases out. So the cases that we take are cases where we can prove through scientific advancement, scientific testing, or additional investigation that the conviction was factually, that our folks are factually innocent. In other words, we don't take cases where the issue is the police behaved in some way that was misconduct, but the person still did the crime. We don't take those cases. So the only cases we take are people that did not do it or no crime was committed. So there are some cases where there's scientific advancement that tells us, hey, this person actually perished, from a disease and not from this other thing that we thought they died from or something like that. So we only take those cases. How we do that is we do all that work on the front end before we even take people on as a client. So we do this, we consult with scientists, we stay up to date on all the forensic science, we go to all the forensic science conferences, we learn from all of that evidence, and then we consult those folks and say, what do you see? What are we seeing here? What are we looking at? The majority of cases that we get that apply to us, we close and we don't take, either because we can't prove it or we, in the end, can't, even if we can't develop it, sometimes it's the case that you prove the opposite, and we don't take those cases either. It's a fraction that make it through. I'm only litigating actively 1 case in New Hampshire.
Thanks.
Yeah.
Okay, are there any further questions? Seeing none, thank you very much for your testimony.
Thank you.
The chair will call Kate Horgan.
Thank you, Madam Chair. My name is Kate Horgan. I'm here representing the Association of Counties. The Association of Counties is opposed to this bill. The county attorneys are really concerned about the language, especially on lines 4 and 5, that essentially leaves no time limit whatsoever on when to request a new case. We are happy to work with Senator Whitley and the stakeholders to see if we can't put in some guardrails that would make everyone either slightly unhappy or slightly happy. But I will conclude my testimony and happy to take any questions. But reminder, I'm not a lawyer, so.
Thank you very much for your testimony, Ms.
Sure.
Horgan. Senator Whitley has a question.
Thank you, Madam Chair. And if you just want to bring this question back, I think that would be really helpful. So we heard, we heard some testimony that 32 states have no bar. And so I'm curious to hear sort of what are the unique situations in New Hampshire to support, the county attorney's position about that.
Sure,
Yeah.
I can take that back to Attorney Halverson. He's been taking the lead on this, but unfortunately was unable to be here today, so.
Yeah. And
Yep.
follow up?
Follow up?
And same about how, why they sort of are a little bit out of step with the ABA recommendation.
I'm happy to take that back
Thanks.
to them.
I appreciate that, Kate. Thank you.
Yep.
Are there any further questions? Seeing none, thank you very much, Ms.
Thank you.
Morgan. Are there any other members of the public that would like to speak to Senate Bill 507? Okay, seeing none, we'll close the public hearing. He's not here today? Where is he?
Oh, yeah, he leaves at noon.
Oh, okay.
Yeah.
Senator Ricciardi? Kathy, can you call Senator Ricciardi Davis to see if he is? Huh? Yeah.
I suppose I'm supposed to declare it.
What?
I have to declare it, and it's right, I can participate, but not.
If you want to go ahead and do that. Oh, PFAS, yeah, you can, oh, there she is, okay. Before I open the public hearing, I'll recognize you. Um, in fact, I will do the same thing. Yeah, I just want to make sure that it's, yeah, I'm gonna turn it on, but it's at 1:30. We're at 1:32, okay. I'm gonna go ahead and open the public hearing on, Senate Bill 413, but before I call the prime sponsor forward, I know that I need to make a public declaration that I have a conflict of interest. Oh, I'm going to go ahead and open the public hearing on Senate Bill 413. Before I have the prime sponsor come forward, I need to make a public declaration that I have a conflict of interest because my home, our water system is contaminated with PFAS, but I am going to be participating. And I'm going to recognize Senator Abbas.
Thank you, Madam Chair. I also have to make the same declaration of conflict of interest. My family and I live on Canopy Lake, which is the town of Salem's drinking water for a large portion of the year, but also there is PFAS in there, and I believe my understanding is the definition that's should be coming out very soon by the EPA would deem the lake contaminated, so I would just make that disclosure.
Thank you, Senator. Okay, Senator Ricciardi.
Thank you. Good afternoon, Chairwoman Carson and members of the committee. I am Denise Ricciardi, representing District 9, stretching from the beautiful towns of Bedford to Hinsdale. Clean water is an issue that is incredibly important to me. I have made it a priority to expand access to clean water for families in my district and across New Hampshire. One of the greatest challenges in polyfluoroalkyl contamination, as we've started testing for these hazardous forever chemicals, we're finding thousands of Granite State families at risk. While we've dedicated millions of dollars to connecting these families to reliable supplies of clean water, it has been difficult to hold polluters responsible for the cleanup effort. Senate Bill 413 would create strict liability for the contaminant and cleanup of hazardous materials and authorize the Attorney General to institute a civil action so that we can recover the costs from the people responsible for the pollution. Senate Bill 413 would also hold the individuals running PFA facilities personally responsible for clearing up the PFA contamination they caused. I want to thank the Department of Environmental Services and the Attorney General's Office for help crafting this important legislation. I do want to talk a little bit more about the in-depth part of this. I want to say that our property owners throughout the state, our residents, schools, businesses, and other entities have been impacted by polyfluoroalkyl to the tune of excess MCL set forth in RSA 485-16-E. And the installation of drinking water treatment systems or connection to a public water supply is extremely necessary to prevent consumption of drinking water at unhealthful PFA levels. A party with significantly greater financial resources than an impacted property owner has typically caused or substantially contributed to the PFAS drinking water contamination. And a property owner's cost of legally establishing responsibility for contamination typically equals or exceeds the cost of remediation through installation and maintenance of an at-point of entry system, POET, or connection to a public water supply. And as a consequence of the resulting economic advantage, a responsible party typically has the financial burden of remediating PFA contaminated drinking. Inequitable shifted from responsible parties onto non-responsible parties, including property owners. So this is why this bill is so important. And I want to also inform the committee members that this was a really collaborative effort. There were I have an amendment because there was some concerns about local businesses that may not know that they have PFA contamination and then they would be held liable. This bill is not about harming our local businesses. This bill is about the point of origin, about the actual polluters that are contaminating our great state. And we need to be responsible and take care of the people and the health of the Granite Staters, and it should not be at the burden of our towns, our municipalities, or the state. And there are people behind me that can answer maybe more technical questions. And again, I have to thank the Department of Environmental Services and the Attorney General because they really worked so closely in crafting this bill to help everyone. So thank you.
Thank you very much for your testimony, Senator Ricciardi. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
The chair will call Mike Wimsatt. Good afternoon, Mr. Wimsatt.
Good afternoon, Madam Chair, members of the committee. For the record, my name is Mike Wimsatt. I serve as Director of the Waste Management Division for the New Hampshire Department of Environmental Services. And I'm pleased to be here before you this afternoon and appreciate the opportunity to testify in support of Senate Bill 413. Essentially the sort of main effect of Senate Bill 413 is that it establishes a private right of action for a person whose drinking water well has been impacted by PFAS contamination. And then the second thing it does is it goes and clarifies some of the general liability provisions, not specific to PFAS, in RSA 147B, the Hazardous Waste Cleanup Fund statute. So DES does indeed support the bill. And I understand that Senator Ricciardi has indicated she has an amendment, which we've discussed with her. And certainly, as this moves through the process, we're happy to continue to help and support to try to make this bill work for everyone. Section 7 of the bill, again, is the primary effect, and I believe the really achieves the goal that Senator Ricciardi was looking to achieve when she sponsored this legislation. It requires that if an owner and operator of a PFAS facility, which would be essentially defined as a facility that has caused, whose releases have caused contamination of groundwater or surface water of greater than 100 parts per trillion in total of the 4 compounds that we currently regulate. We regulate 4 individual PFAS compounds and have standards both for ambient groundwater quality and for drinking water for those 4 compounds. So a facility that's caused contamination in excess of 100 parts per trillion in total concentration of those particular contaminants would be liable to provide safe, clean water to anybody whose well they've impacted above drinking water standards. And what that essentially does, and the way that that would happen is that in the first instance, if practicable, that's expected to be a water line. If that is not practicable, and it often isn't, then a point of entry treatment system in that individual property to treat that property as well. So in essence, what that does is it provides an individual property owner, it could be a homeowner, with a firmer legal footing so that if they are in a situation where their well's been impacted and they're not being offered safe, clean water, if they wish to take a private action to try to accomplish that, this gives them a firmer legal footing than they would enjoy right now. And that's, I believe, the real thrust of this bill. As we move on, Section 5 of the bill affirms that owners and operators of PFAS facilities, and again, those are facilities that have caused greater than 100 parts per trillion contamination in water, are subject to the liability provisions of RSA 147B, one of our hazardous waste statutes. And Section 3 clarifies that a person responsible for a release of hazardous materials or hazardous waste is liable not just for the costs associated with, that the state might incur to address that release, but also to actually conduct the containment and cleanup operations that are needed so that the state doesn't have to take that action. And then it goes on further in another section of the bill to make it clear that the Attorney General has the authority to not only recover costs, but also to ensure that it has the authority to require injunctive relief, to require a person who's responsible for contaminating groundwater with a hazardous waste or soil, or any release of a hazardous waste or hazardous material, that the Attorney General has the authority to both recover costs and to compel that party to do cleanup. So that's really a whirlwind tour of what this bill does, and I'm more than happy to answer any questions that the committee may have.
Thank you very much for your testimony, Mr. Wimsatt. Are there any questions from the committee? Senator Gannon.
This probably isn't on point, but you can help me anyway. So if I buy a factory, use it for another use later that produced PFAS, and I buy the land and the building and everything, am I going to be responsible for their?
That's a complex legal question that would probably depend on the nature of the purchase. We have a lot of situations where, you know, a responsible or a new owner of a facility goes in, and when they purchase the facility, they do their due diligence and they learn that there's been a release or contamination, and they basically negotiate as part of the sale that liability remains with the original person who actually caused the contamination.
Okay, thank you.
Are there any further questions? Senator Abbas?
Thank you, Madam Chair. Can you explain where the number, like the 100 part per trillion came from, how that was arrived?
Sure. Yeah, when we assisted Senator Ricciardi with drafting this bill, we understood that she was not looking to ensnare every, you know, I mean, I'll give you a story. My own home, I have a certain kind of tile on the floor of my kitchen, and I learned that the wax or the finish that's on that has a lot of PFAS in it. So what I think Senator Ricciardi was trying to do is make sure that Mike Wimsatt, if he discharged some of that to a septic system, didn't get caught up by this. And also not that small businesses and other entities that might have had a release of small amounts of PFAS wouldn't get caught up in something like this. So the 100 part per trillion number really reflects what we see usually when a manufacturing facility has had some substantial release, and we see that kind of concentrations in groundwater. It doesn't mean that drinking water wells may be impacted at that level, but they've had a substantial release that's caused that kind of contamination. And then in some cases, they may actually impact drinking water wells at a lower concentration, but a concentration that's still above the drinking water standard.
Thank you.
Sure.
Okay. Are there any further questions from the committee? Seeing none, thank you very much, Mr. Wimsatt.
You're welcome.
Okay, the chair will call Christopher Van Duzen. Sorry, I'm sorry I butchered your name.
That's quite all right, Sim. Thank you, Madam Chair, members of the committee. My name is Chris Bandazian. I've been involved in PFAS contamination since it was discovered in February of 2016. First as a member of the Bedford Town Council when the Legislative Study Commission for the Study of Environmental and Health Effects of PFAS contamination was established. I became the town government member, where I currently serve with Senator Carson and formerly with Senator Chanley. I'm currently, for the last 2 years, chair of the Study Commission. I think we all would agree in working with the state that as servants of the public, the highest priority has been to provide properties with safe drinking water as quickly as possible. And although a great amount of has been accomplished over the last 8 years, there is still a tremendous amount of work to be done. Probably the Department of Environmental Services has had tens of thousands of communications with individual residents over that period of time, as well as the Attorney General's office. And ultimately, they have global concerns, legally and environmentally, that sometimes are not on the same timeline as individual concerns. So this bill will go a long way to helping individuals get safe drinking water faster. They will be more in control of their own destiny. Right now, a business with much greater financial resources can simply stonewall the process. We currently, in the St. Gobain consent decree area, the most highly scrutinized area in the state for the last 8 years, still have at the beginning of this month 250 properties that have not even been tested. So we don't know if those individuals have been drinking contaminated water or not. We hope they're the least likely to have been drinking contaminated water, but the process drags on. This would put some potency into their ability to get the issues resolved. And certainly, I think, again, it will go a long way, not just in this particular area affected by St. Gobain, but statewide, and would allow the state Attorney General's office and Department of Environmental Services just to somewhat get out of the business of representing individuals, and would allow them to continue to address big problems globally. So if there are any questions, I'm happy to answer them. I guess the other thing I would add is with the attorney for fee provision, I have a little bit of experience in an analogous field, dealing with denied medical bills in the workers' compensation arena. For years and years, attorneys were not compensated, and so individuals just went bankrupt because they couldn't pay bills and afford a lawyer to recover money that they would simply turn over to a medical provider. There is a similar provision for reasonable fees at hourly rates, and it very quickly, it became a much more rational playing field. When there were deadlines imposed and companies realized that they had to pay bills that they should pay, it began happening, and I strongly suspect that's what will happen here.
Thank you very much for your testimony. Are there any questions from the committee?
Thank you both.
Seeing none, thank you very much. The chair will call Kirsten Cohen.
Good afternoon, Madam Chair, members of the committee. Thank you for the opportunity to be here before you today. For the record, my name is Kirsten Koch. I'm the Vice President of Public Policy for the Business and Industry Association, known as BIA. I'm here today to oppose Senate Bill 413. We have great concerns with the bill. We believe it diminishes existing legal standards, propels anti-business ideology, and contains overly broad language that will likely create a wave of unintended consequences that will severely harm the business climate in New Hampshire. I just received this copy of the amendment. I've had a few minutes to look it over. My testimony is based on the bill as introduced. I will say, in the few minutes I was able to glance over the amendment, that it does serve as a modest improvement, but we feel as though it has some exemptions. It's still concerning for industry. So our first concern is that Senate Bill 413 contains an overly broad and sweeping definition of PFAS facility. Under the bill is introduced an entity that manufactures a product that contains pre-made parts generated elsewhere that contain PFAS materials could be held liable just because PFAS was used, treated, stored, generated, disposed of, or otherwise came to be located at the location. The bill as introduced would be problematic for a variety of entities beyond businesses, such as fire departments, wastewater treatment facilities, municipal wells, schools, universities, hospitals, and current property owners of previously contaminated sites. We also believe that Senate Bill 413 diminishes the existing legal standards by lowering the burden for the state to prove a case for the benefit of those pursuing action against business. We believe that the existing legal processes allow for bad actors to be held accountable in a court of law as necessary. And BIA is aware of no circumstance in which the existing process has been insufficient to protect the environment. What's equally concerning is that the bill includes a provision that would allow affected private parties to sign over their rights to specialty or claims adjustment firms who would make a living out of chasing New Hampshire businesses for settlements. Our concern here is that this was possibly a proposal set forward to benefit the plaintiffs' bar in establishing an industry of PFAS litigation on the backs of New Hampshire businesses, ultimately possibly driving them out of business. The amendment language touches on this a bit, but we had a concern that Senate Bill 413 would prevent a PFAS facility from asserting the same statutory defenses to liability under RSA 147B10A. I believe that's addressed in the amendment, but we did have concerns in the bill as introduced also about whether the bill would eliminate the protection under RSA 5077E, and that's about joint liability. Further, the bill would be detrimental to small businesses who've unknowingly had PFAS come to be located at their facility. We've touched on this a bit earlier, not the previous testimony, but our concern is, for example, you take a small local farm who unknowingly received contaminated sludge, and they could be considered to have passively released this PFAS and then would be liable for an enormous amount of money and have lost some of the protections of law because of this bill. As a result, we're also concerned that Senate Bill 413 would open the floodgates for new litigation between and against businesses. We think the cost of this litigation could be tens of millions of dollars for businesses, also driving them out of business. Lastly, we are concerned that Senate Bill 413 could interfere with ongoing New Hampshire DES remedial investigations. Under this proposed litigation, while the state is trying to conduct an orderly investigation with one or more sites, we believe that this gives private parties the authority to race into the courts to file suits, ultimately undermining the efforts of an organized and efficient remediation by New Hampshire DES and driving up the cost of the process for business. In conclusion, we find that the amendment is a modest improvement, but we still have so many concerns with the bill. We'd ask the committee to please vote in expedient to legislate on this bill. I appreciate your consideration. I'm happy to try to answer any questions.
Thank you very much for your testimony, and I apologize for getting your name wrong.
It's okay.
I should know, she used to work for me. I should know it, but are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
The chair will call Michael, it looks like Strand. Good afternoon, Mr. Strand. Sir, can you turn your microphone on, please?
Now we're on? Okay. Clearly new at this. So I am here today on behalf of the Bedford Town Council. I'm also here in my capacity as the appointed citizen representative on the PFAS Commission for Bedford. And first, I want to share letters from the town manager and chairman from the Bedford Town Council that are in support of this bill. So I just gave you some qualifiers here. Another qualifier that could be relevant is what I am not, and that is a paid lobbyist, although I'm starting to feel like a free one lately. I've spent a couple of years on this issue. My role primarily is to help triage and field concerns from affected residents and help them navigate this mess, more specifically for towns that have wells that are, acutely contaminated with PFAS. I want to thank Senator Ricciardi for writing and sponsoring this bill. And, I think it's important to protect people. I think that she was courageous to do so. And I think we need to make life a little bit easier for people who already are dealing with an issue that I am shocked we're even talking about in the year 2023, let alone in New Hampshire, the live free or die state. I'm not a legal expert. I am not a scientist, but I can offer perhaps a human lens to this issue in Bedford anyhow. I never thought, I'd be in a situation where I'd have a guy on my basketball team asking me whether I think it's okay for his pregnant wife to take a shower in their house because PFAS contamination most seriously affects pregnant women. He was right below the MCL and outside of the consent decree and had no recourse besides buying his own, whole house filtration system, which I advocated he do. It's difficult when you have 30 and 40-year Bedford residents coming to you and talking about several people on their street who have, dealt with cancer. It's not something people often publicly want to talk about. And so, this is really primarily about public safety. But what I've also learned, it's really about taxpayer and property owner interests as well. The way that we're currently handling cleanup, which is through, state programs or rebates, in my opinion, are the equivalent of, taxpayers subsidizing our own corporate chemical polluter, which is not okay. And I think this bill goes a long way in addressing that. We ran into an issue where people who were going through the DES program to get filtration system reimbursements were getting 1099s because you have to do that. And so people were then being asked to pay federal taxes on a rebate program for water contamination caused by a private entity. Not okay. We actually had to go to our federal delegation and, reach out on behalf of affected, property owners to try and change the tax code, at the federal level to deal with this. So it's just, I think we need to have, we need to be deliberate, I guess, in our frame of reference. We really need to put people over money right now. There's nothing pro-business about these sorts of emissions and contamination that happens when you look long-term. And so, I'll share a little more and not take up a whole lot more of your time. I've had a lot of people inquire, about filing suit. And I'm not qualified to offer that advice, so I don't. Other than saying if you have the time and means, I certainly would. But, I think it's burdensome. It's prohibitive for the average family, loss of time, money, legal costs, especially if you're a working family. People are more worried about paying their bills, whether they can fill the pool up in the summer, whether spaghetti night comes with caveats when you boil the water, forget about drinking it. I think people deserve the easiest path to legal recourse and justice here without undue burden. They deserve both, judiciary and a general court of Senate willing to protect property rights and people, not a 300-year-old French multinational company. And if you don't do this for those affected who have been denied justice or adequate remuneration, I would urge you to do this for yourselves. I want to see you put this bill on the floor so that as legislative leaders and senators, you did the right thing. So when you go home today, you hug your kids, you can look them in the eyes and you know that you defended the basic property rights of New Hampshire residents and property owners. And you defended kids' inalienable right to drink clean water. That's what this is about. That is all this should be about. It's about a government that will do no harm, a government that will let its people defend themselves to the fullest extent of the law, protect their property, protect their wells, and protect their families. Thank you.
Thank you very much for your testimony, Mr. Strand. Are there any, Mr. Strand? I wanted to see if there are any committee members that wanted to ask a question. Nope, you're good.
Thank you.
Okay. Are there any other members of the public who would like to speak to Senate Bill 413? Okay, seeing none. We close the public hearing. I'm up next. Need to turn your mic on.
Okay, we're back in session. Senate Judiciary, Senator Carson's going to introduce 423.
Thank you again, Mr. Chairman, and it's good to see all of you again. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Auburn, Londonderry, and Hudson. And I have for your consideration this afternoon Senate Bill 43 relative to mandatory disclosure of insurance policy limits. Mr. Chairman, Senate Bill 423 would require insurance company to disclose policy limits pre-suit. This bill simply requires that when a person causing damages to another has insurance, the insurance company must disclose what the policy limits are upon request. New Hampshire Superior Court Rule 22A4 requires disclosure of the insurance policy, excuse me, and the policy limits after a lawsuit has been filed. Senate Bill 423 recognizes that most civil cases settle pre-trial, and access to information that would be disclosed in the course of litigation anyway be disclosed earlier in the process. Excuse me. New Hampshire is the only New England state that does not require pre-suit disclosure of policy limits. The language in the bill before you was taken from our neighboring state of Maine and is very similar to, in statute, to every single one of our neighboring states. We know that in New Hampshire, the vast majority of civil cases settle, again, pre-trial. This saves time and money for all parties involved without having to go through costly litigation. There may be concern that if an injured person knows the policy limits, that will become the amount that will be claimed in the case. This is unfounded. A person's damages in a case are determined by many factors, such as medical bills, lost wages, pain, and suffering. The assessment of damages will need to be supported by the evidence. Simply knowing what the policy limits are in a case does not change those calculations. And finally, Mr. Chairman, this bill simply ensures that a person injured by a person with insurance coverage available to them knows how much insurance coverage is available to cover the claim. Senate Bill 423 does not impact costs of damages. It merely informs the injured person whether the person who caused their injury has sufficient insurance coverage, excuse me, or not. The bill makes this disclosure mandatory without having to file a lawsuit and will encourage judicial economy. Mr. Chairman, at this point, I am going to conclude my testimony. There are folks behind me on both sides of the issue that are going to be able to answer questions much better than I can. So I thank you for your indulgence this afternoon.
Thank you, Senator Carson. Rep. Will Infantine.
Good afternoon.
Afternoon, Representative.
My name is Representative Will Infantine. I represent Manchester, and I'm the chairman of the Labor Committee. I'm here to speak against this bill. I have been an insurance agent for 35 years. I've owned my own insurance agency for over 25 years. I've served on the State Board of Directors of the Insurance Agents Association, and I now serve as a national representative to our association for New Hampshire. So that makes me pretty much the biggest insurance nerd in the room probably right now. We have a delicate balance right now in the state of New Hampshire regarding insurance and the legal industry. Both of them serve a very important part of how things work. Millions of dollars a year is paid to insurance companies and insurance premiums, and millions of dollars a year goes out to pay claims. And in New Hampshire right now, it works. And I feel this is a major disruptor. To determine whether or not, I listen to what the senator says, and it pains me to speak against the senator, who is a friend of mine. But there are specific ways that things get done these days. You are aggrieved, you file a lawsuit through a deposition, through an interrogatories, you get the information you need. I think that has worked well. I don't think it's appropriate just to have go to your neighbor's house, which this bill would kind of allow. If you went to your neighbor's house and in writing said, hey, here's a letter here. My kid got hurt in your backyard last week and you're gonna need to tell me your insurance limits. First of all, I have a privacy issue with that without someone filing a lawsuit. Secondly, the system allows someone to find out that information through interrogatories versus someone looking and saying, well, I'm not sure whether I'm going to take your case because I'm not sure there's enough insurance coverage to make it worth my while. I have a real problem with that. And the comment was made about New Hampshire being the only state in New England. Good. I'm glad. We do it right. That's why we have a lot of insurance companies willing to come into the state of New Hampshire and do business. Because everything, as I said, it's a delicate balance and it works. Again, I feel this would be a major disruptor. I like the way it works, and I would be very much against this. There are a lot of other people that will say more, I'm sure. But having done this for so long, again, as I said, I'm the biggest insurance nerd in the room. It works. The way we have it works. Please keep it the way it is. Thank you.
So to sum up, I think what you just said, pre-suit disclosure encourages fishing expeditions. Is that what you're saying?
That's a negative. That's one of the negative parts. Senator Carson mentioned one of the positives. Well, there's an economy of scale and trying to find out, but I don't think that's the way the justice system should work. All right, determine what the coverage is first, and then decide whether you're worthy of representation. No, I think there are some positives, but I think the negatives outweigh the positives.
Thank you, Representative. Any other questions? Seeing none, thank you.
Thank you.
Just him. Will, yep. Only one I've done. You still got a lot to go.
Yep. Okay. Let's see. Sorry. The chair is going to call Heather Menzies. Good afternoon.
Good afternoon. Thank you, Madam Chair and the committee. And thank you, Madam Chair, for sponsoring this legislation, which is common sense legislation. It merely requires pre-suit, what you get very early on after filing a lawsuit anyway. It simply provides that where a person is injured by someone else and that other person has insurance, the insurance company then has to provide what those policy limits are. And again, as Senator Carson had mentioned, the Superior Court rules do require within 60 days of someone filing an appearance on behalf of a defendant, automatically the entire policy is provided to the injured person. This bill simply just requires disclosure of the policy limits upon request. So the injured person or their attorney would have to request of the insurance company, not the individual neighbor, of the insurance company, what the policy limits are. And perhaps probably the best way to demonstrate why this is such common sense legislation is with an example. So suppose you have a driver who's texting while driving, blows through a stop sign, hits another driver, and that person's paralyzed. Now, if when the police arrive, they get all the information, that police report's going to have whether the texter had insurance, even provides the policy number, the company itself. Now, assume the person who was injured also has motor vehicle insurance. That person may have what's called underinsured motorist coverage. And that's where the person injured has more insurance than the person who caused the accident. But the problem is if you don't know how much insurance the person who caused the accident has, you don't know whether you even have an underinsured motorist claim. And so unless that insurance company voluntarily discloses the limits, that person doesn't know. And that's not fair. And I've actually had cases where I've had to file the lawsuit simply to get what the policy limits are to determine whether my injured client even has an underinsured motorist claim. Now, that's just silly. That really shouldn't have to happen. A lawsuit shouldn't have to be filed for something as simple as just disclosing what the policy limits are. So, that's one example. In practice too, this is not something burdensome. I've dealt with insurance company. I think I neglected to mention, my name is Heather Menezes. I am an attorney at Shaheen and Gordon. I do personal injury law. And so in dealing with insurance companies from other states, pretty much any other New England state, I've done this. It's a simple letter to the insurance company. Please provide the policy limits. And it's a simple letter back that just has the limits. It's not burdensome. This is information that's readily available to the insurance company itself. It's not like they have to do a lot of work. It's all the information that they have readily available to them. This is not something that's going to be a major disruptor. It is also the concern that there might be that knowing the policy limits will then determine what the person claims in damages. As Madam Chair stated in her opening statement, that's not how attorneys, I am one of them, that's not how we determine what the case value is. I've had plenty of cases where I've had a lot of insurance coverage available, but the damages in my case didn't warrant it. And the case settled for a lot less than what those limits are. So it's not like a gas that fills the room and automatically we get the policy limits. It's just simply not how it works in practice. In addition, even though I was talking about an example with a car accident, this is not a situation that's just limited to that. Another situation where this would be helpful and help settle cases rather than filing a lawsuit is if I had a really bad dog bite case. A child was bitten on the face. There's a lot of medical coverage bills, and they have a horrible scar. If the insurance available is really low, the case should resolve really quickly. I shouldn't have to file a lawsuit to then learn, oh, there's not sufficient coverage for this person. Let's get this wrapped up soon. And that family shouldn't have to go through filing a lawsuit to get what really should have been disclosed in advance of a lawsuit. And so the last point I wanted to make is that there is a penalty provision as part of the statute that is exactly the same as what Maine's is, because otherwise the insurance companies are just going to ignore the request. I haven't found there's been any issues in any state that I've dealt with when I've requested the insurance policy limits. If it's any other state other than New Hampshire, they just, give you a letter within I mean, I think it's 60 days is what Maine's is. Massachusetts, I believe, is 30 days. And usually they're providing that well before even that deadline, and it's really not an issue. And I'm happy to answer any questions.
Thank you very much for your testimony. Are there any questions from the committee? I just have a quick question, and I'm not sure if you know the answer. I talked about New England and how we're the only state in New England that does not do this. Do you have any idea about the rest of the country?
I don't know what the split is. I do know there are definitely other states outside of New England that do have mandatory policy limits, but I do not know what the numbers are of states that do versus that don't.
Okay, thank you.
Thank you.
Are there any further questions? Okay. Seeing none, thank you very much.
Thank you.
The chair will call John Pageau. Oh, it's Joan. Oh, I thought it was John.
That's okay. My penmanship isn't what it should be. Good afternoon, and thank you for allowing me to speak on this issue. My name is Joan Pageau. I'm the president of the New Hampshire Association of Insurance Agents, representing over 200 insurance agency business owners and more than 6,000 individuals. And I am speaking in opposition of this bill. I won't reiterate many of the very good points that Representative Infantine made, but I will add just a few comments of my own. And to restate that when a suit is filed against an individual or business, policy limits are provided. Under this bill, however, requests can be made asking for policy limits before any suit is filed, and individuals and businesses would have to respond. Then, after that information is made available, a decision can be made whether to move forward with a claim or a lawsuit. This bill opens the door for people to ask for and receive what I consider to be private information that has no bearing until a lawsuit has been filed. And the insurance agent will be burdened, put in the middle, and burdened with trying to figure out a policy's limits that would apply when they don't know the full reason for the request to disclose. So on behalf of the New Hampshire Association of Insurance Agents, I respectfully ask that you ITL Senate Bill 423. Thank you.
Thank you very much for your testimony. Are there any questions? Senator Chandler.
Thank you, Madam Chair, and thank you for taking my question. You just said that this would require that private information be disclosed. Is the private information you're referring to simply the limits?
Yes, the policy limits. I mean, I may carry very high limits for any number of reasons. Or on the other side of the coin, I may carry state minimum limits for whatever reason may be. But whether the information that I have very low limits or very high limits shouldn't be the basis for a claim or a lawsuit. And I believe that this opens that door.
Thank you.
Are there any further questions? Seeing none, thank you very much for your testimony.
Thank you.
The chair will call Lindsay Nato.
Thank you, Madam Chair. For the record, my name is Lindsay Nato. I'm an attorney at Orr in Reno here in Concord, and I'm here on behalf of two clients, the New Hampshire Association of Domestic Insurance Companies, as well as the national trade group, the American Property Casualty Insurance Association. We do have serious concerns with the bill, and I am here in opposition. Essentially, the bill is really open-ended and one-sided compared to what other states do. It would significantly alter the balance that's currently in place. As drafted, the bill allows anyone to make a request for any reason, with or without good cause, to any individual or business about their policy limits. It's wide open. This is an unnecessary burden, and as we've heard from others, we see it as a violation of privacy to the businesses and individuals who are receiving the request. It is in the interest of all parties to settle cases without the expense of going to litigation. And generally, as we heard earlier, most cases do resolve themselves and settle pre-litigation. I would submit to you, this is an indication that the system is working. People are getting the information they need to resolve their cases. While there may be times when an insurance company does not disclose a policy limit, we believe they're rare, and most of the times they are provided when the circumstances require it, and it's justified given the information the insurance company receives. Keep in mind that whether to disclose or not is up to the insurance company, whose duty is to protect its insured. The relationship is between the insurance company and the insured, not to a possible claimant or a possible claimant's attorney against that insured. From the insurance company's perspective, that's the relationship that matters. If there is a situation where a company is not, for some reason, disclosing a limit, which again, I don't think is that often, a claimant may file a suit, as you've heard, and based on the merits, and will automatically receive that information as part of the discovery process very early in litigation. Superior Court Rule 22 in New Hampshire, as you've heard, as well as its corresponding federal court rule, already requires automatic disclosures by both parties. This bill only applies to possible defendants. Automatic disclosures in a lawsuit apply equally to both parties. So therefore, when a defendant is giving information about its policy limits or policy terms, it has the benefit of having read the complaint and knowing the facts and the reason and the alleged liability for that claim and why its insured may be liable. This bill is one-sided. Unlike in a number of states, a potential claimant is not required to provide any information about its request. You can walk up to your neighbor and say, I want to know your homeowner's policy limit, and they have to tell you. Many states require the requesting party to provide the insurer with information, so it's a mutual disclosure obligation. Senator Carson, I want to say 17 or 18 states currently have some pre-suit disclosure requirements, so the majority of states do not have a pre-suit disclosure requirement, but of those that do, it's often mutual. The potential plaintiff has to disclose things like the date of an accident, copy of a police report, medical records, medical bills, lost wages, and whether any third parties are funding a potential lawsuit. Transparency is a two-way street. If a potential defendant is going to be required to disclose information, then we think a potential plaintiff should also have some disclosure requirements, which is currently what happens under the automatic disclosures in the early stages of a court case. Again, the majority of states don't require pre-suit disclosures, and certainly most states are not the type of broad disclosure for all types of insurance that this bill would encompass. SB 423 isn't limited to auto accidents, which many states do limit it to auto accidents. Instead, this would apply to all kinds of claims and all liability policies, including homeowners, business liability, medical malpractice, and other professional liability insurance, as well as a person's umbrella policy limits. Excuse me. In most states like New Hampshire currently, the nature and amount of insurance that an individual or a business chooses to voluntarily purchase is private information. It's not subject to public disclosure. It's between that person or business and their insurance company. This bill would subject businesses and individuals to the burden of contacting their insurance agent or insurance company to confirm their coverage and guess what coverages might apply to a situation without even knowing what it is they're accused of doing. Therefore, we believe that any utility of the legislation is far outweighed by its costs and violations of privacy, and we hope that you'll find it inexpedient to legislate. Happy to take any questions or get answers if I don't know them.
Thank you very much for your testimony. Are there any questions? Seeing none, thank you.
Thank you.
Okay, the chair will call Kirsten Schultz. Good afternoon, Ms. Schultz.
Good afternoon, Madam Chair and members of the committee.
I'm Kirsten Schultz. I'm an attorney with Nixon Peabody, and I'm here representing State Farm, which is one of the leading writers of auto and home insurance in the United States and here in New Hampshire. We're here to oppose SB 423, and the reasons for our opposition to the bill largely track the concerns raised by others who've spoken previously in opposition. But we've also submitted written testimony for the record, and I can spend a moment summarizing its main points. First, as written, SB 423 could incentivize the targeting of people who purchase insurance, people who make the responsible decision to enter into private contracts for the purchase of insurance. It raises concerns, as Chair Carson, you referenced earlier, about claimants' demands being essentially reverse engineered, meaning that they would be calculated differently to reflect the full amount of insurance coverage that may be available, rather than the amount that would properly reflect the actual damages incurred, if any. And those damages are wholly independent. Those calculations of damages are wholly independent from any potential insurance coverage that exists. And I have to respectfully disagree with the testimony from others today that knowing the policy limits up front would not change necessarily that demand amount. Perhaps in most or many cases it would not, but in some cases it would. There are certain categories of damages that can be more easily itemized, like medical bills, lost wages. But other categories of damages are much more easily inflatable all the way up to the policy limits, like pain and suffering or emotional distress. Second, the bill also may create confusing or problematic overlaps with existing court rules that already require disclosure of much of the same information post initiation of litigation, but with different timeframes. So even if there is a 60-day timeframe under Rule 22 in the Superior Court, there are often extensions that are requested and granted, things like that. So if we have this statute, then we also have a court rule in state court, and then we get a separate time frame in federal court, which one would apply and when. There's that confusion potential. And in court, when insurance information is disclosed, it's one of the initial disclosure items that gets disclosed right up front generally. But it is not the entire policy. It's usually the declarations page, which contains the policy limits with the premium amount generally redacted. Right now claimants are entitled to that insurance policy information after they filed a lawsuit. And by filing that lawsuit, they or their attorney is essentially certifying that the claims are properly grounded in law, that they have some factual or evidentiary support, that they're not frivolous. And the bill, as written, seems to allow anyone to obtain that same otherwise privately held insurance information on demand without any of the corollary requirements that the requests be made in good faith or that the information requested be protected from further dissemination. Third, and finally, the bill contains no threshold requirements or guardrails against frivolous or unmeritorious claims, such as those that exist in other states' statutory or regulatory frameworks where pre-litigation disclosure of policy limits is allowed or required. Ms. Nato just addressed, Chair Carson, your question earlier about how other state statutory or regulatory frameworks deal with this issue. And just to fill in a few more related points, among the several states, and I think as of 2022, the count was about 17 or 18 plus District of Columbia, that require any pre-litigation disclosure of liability policy limits. But many of those, perhaps even most of those, do impose these threshold requirements that are absent from this bill, from SB 423 in its current form. So the claimant has to provide certain documents or evidence supporting the claims. There are confidentiality protections that apply to the disclosed information. There are protections against the unnecessary disclosure of excess or umbrella policy limits, which is very important. Some states also restrict their laws to automobile insurance coverage, and they exclude fleet policy limits. And then some states even go so far as to require claimants to submit to pre-litigation mediation if they go this route. None of these parameters are contemplated by SB 423 in its current form. So for these reasons, we oppose the bill, and if there are any questions, I'm happy to try to address them.
Thank you very much for your testimony, Ms. Schultz. Are there any questions from the committee?
Thank you.
Seeing none, thank you. The chair will call Mike McLaughlin.
Good afternoon, Madam Chair and members of the committee. My name is Mike McLaughlin, Allstate Insurance in Maine, New Hampshire, and Vermont, and here to testify in opposition to the bill. I won't repeat what a lot of other people said, but we'll make a couple of points. One is that we're talking about property casualty insurance and claims, and to the best of my knowledge, 99% of property or casualty claims are advertised by lawyers as a no fee until recovery is made. So the claimant is not prejudiced and doesn't have any extra cost when he engages an attorney and says, would you take my case? This bill doesn't do anything to help that or hurt that claimant. Another interesting thing is that a state where we treasure people's individual rights, this bill is saying to the insured, I have no participation and no say in what you do with my policy. You're going to have Mr. X have my insurance through Allstate, and suddenly you're going to tell Allstate to disclose my policy. I haven't made that decision with Allstate. I don't think it's fair that the insured is cut out of the decision on whether or not his personal private information come forward. The pre-suit disclosures things that we have in New Hampshire, the court rules and the statute, have worked very well to do several things. One of the most important things is New Hampshire has tremendous amount of insurance companies coming here to do business. Lots of consumer options, best prices in New England. Adding this level of disclosure, again, is, I think, earlier testimony, can create a fishing expedition. And again, a claimant, I don't see any specific definition of what makes a claimant. Do I think I was injured? Who is the person who's making this claim? The commencement of a lawsuit usually begins with the facts surrounding the claim. This has no threshold limit of how I make how I make my claim. If I simply call up, I have a claimant, I'd like your limits. What's a claimant? Is it someone who has provided some outline and facts that is a basis for the claim? I looked at 402. I didn't see any definitions of the word claimant. So right now we have a undefined term triggering a disclosure by an insurance company based on what? So I don't think the state of New Hampshire has any issues in insurance availability, insurance price, and this law seems to be a little bit unnecessary in a system that's working very well. And I'll take any questions.
Thank you very much for your testimony, Mr. McLaughlin. Are there any questions from the committee? Seeing none?
Thank you.
The chair will call Kimberly Kirkland. Do you want to speak? You signed up to speak. Or Mr. Woodbury, would you? Okay.
Thank you, Madam Chair, members of the committee. My name is Bill Woodbury, and I am a general practice litigation attorney practicing in Laconia, New Hampshire. I also serve as the legislative chair for New Hampshire Association for Justice. We're here in support of SB 423, and I would reiterate the comments made by my colleague, Attorney Heather Menezes. But I'd like to address just a few of the things that were said by the individual speaking before me here. First of all, I think that what we've heard over and over again here is the question about privacy with respect to this disclosure. And there's no, we would certainly have no issue to there being language within the bill that indicated that the information obtained would be kept confidential and within the confines of the litigation, not be released outside the litigation. I don't think that would be problematic in any way. The notion that the system has been working well and works well, I think it's fundamentally flawed. The reality is the system works well for the insurance companies because by forcing an individual by not disclosing policy limits and by forcing an individual to get to the point of having to file a lawsuit just to know whether or not, they might be made whole as a result of their claim, it has I think, a chilling effect on whether or not some of these people are going to file anything at all. As far as the actual statutory language, I think it is clear that it's not anybody who can simply request this information. It's a claimant, and a claimant is an individual who specifically has a claim for injury against the insured. As to, I think it was Representative Infantine who initially referenced, it would encourage fishing. I think that was the conversation between Senator Gannon and Mr. Infantine. And I think the opposite is true. If there's an early disclosure of policy limits, and that early disclosure facilitates productive settlement discussion, then lawsuit probably doesn't need to be filed, and there doesn't need to be this exchange of discovery, and this large-scale reciprocal exchange of information. They would never get there. It would seem that what the individual speaking before me would suggest is that, it's better to burden the court system with lawsuits that need not be filed simply because we were not able to obtain policy limit information, rather than simply provide that policy limit information and engage quickly in reasonable settlement discussion. Now, as was mentioned by my predecessors here, the fact of the matter is once a lawsuit is filed, there is an exchange of information under Rule 22. A mandatory exchange of information, and to my knowledge, there's no confidentiality provision within that rule. I think the issue of privacy and confidentiality, I think it's one, if there's a true concern, is one that's easily remedied with a minor modification to the bill, including a confidentiality provision. But I think it's overstated, respectfully. I have had a number of cases over the years where insurance companies have refused to provide policy limits. I had one recently where an individual was a passenger in a motor vehicle, was severely injured due to the negligence of the driver, and repeated requests to obtain the insurance the policy limits were just ignored. What that results in is our clients are looking to us to provide them information as to, am I going to be able to recover my lost wages? Am I going to be able to recover my out-of-pockets? Is this, should I be pursuing this at all? And we can't provide them the advice we need to provide them to give them that sound advice in the absence of knowing whether or not full recovery is possible, whether or not they're going to be made whole. This isn't about whether or not we're going to take their case, okay? This is about whether or not we can tell them what they can expect, what they're going to be able to recover as a result of their injuries. Senator Carson, you had asked the question, I think to Heather Menezes, what the ratio was of states. A quick look, I believe it is 28 states that do have provisions of this nature, and the District of Columbia. Some are just for automobile insurance, some are across the board liability insurance. In New England, it is all the other states have these provisions. Vermont and Connecticut are limited to motor vehicle, but Rhode Island, Maine, and Mass are not. They are more general. And as you know, we've modeled this language after Maine's statute. The notion, I think, that the information exchange is not reciprocal in the early stages. Again, I think if the concern is privacy, that's easily remedied. And remember, the individual, the claimant, is the injured party. They're at this, they're simply trying to determine whether or not there is coverage available to make them whole for the injuries they've sustained. And again, it's I think the respectfully, I believe that the insurance companies are hoping that this law doesn't pass because they will lose that chilling effect that they have by virtue of the fact that if a plaintiff is forced to file a lawsuit, they may forego doing it in that it may seem far too ominous. I believe that's all I have at the moment, but I'd be more than happy to answer any questions that
Okay, thank you very much for
Committee
your
may have.
testimony. Are there any questions from the committee? Senator Gannon?
Just a little question.
Sure.
You referred to, you said it wouldn't be a factor for you, or if they had the amount of insurance coverage, would you, sometimes you'd be working on a retain, like a third, right? A commission for your victory?
I believe most personal injury cases
Sure.
typically are done
So that
on.
would affect your judgment if they didn't have sufficient coverage, wouldn't it? That you might not take the case if you can't get a sufficient compensation for your time?
I can't speak for all of our members, sir, but I know that when an individual comes to me and they've had this issue, I will do my best to take and do a full investigation as to what their options are. This would be a part of that investigation. The motivation is to be able to tell the client whether or not they're going to be able to be made whole. All right.
Thank you.
Now, the one thing I would mention is that it was suggested that disclosure of the policy limits automatically inflates pain and suffering damages. It's simply not the case. The fact of the matter is you evaluate a case for what the case is. You evaluate the medical bills, you evaluate the lost wages, the special damages, and then you evaluate what you believe that case would be appropriate with respect to asking for pain and suffering. You think about it in terms of what would you ask a reasonable New Hampshire jury? A reasonable New Hampshire jury is not going to just give you, if you know the policy limits are $1 million, you're not just going to demand $1 million on a case that you know doesn't warrant it, because they're not going to award that. You need to evaluate your case as to whether or not you can settle based on how you think a jury would look at your case. So the case is evaluated the same no matter what the policy limits are. So I think that is something that was emphasized. It's just not correct. It undermines and kind of misinterprets how we evaluate our cases.
Thank you.
Are there any further questions? I have just a kind of a question, because there's been a lot of testimony about this, and I just want to make sure that I really understand this. I'm a resident of New Hampshire, have my insurance through New Hampshire.
Yes.
If I go down to Massachusetts and I get into a car accident, somebody hits me, am I able to get that information because it happened in Massachusetts from the other person's insurance company?
The question is interesting. I guess it would depend on, is the case being adjudicated in Mass, and is it being adjudicated under Massachusetts law, in which case, under Mass law, yes.
Okay, that's what I thought. Okay, thank you very much for your testimony. Are there any further questions? Seeing none, thank you.
Thank you.
Okay, are there any other members of the public that would like to speak to Senate Bill 423? You want to testify now? Okay, come on up. We got a few minutes. And please identify yourself for the record.
I'm Kimberly Kirkland. I'm a lawyer practicing here in Concord. I'm also president of the New Hampshire Association for Justice. And the basis for my brief testimony here this afternoon is really from my experience teaching civil procedure at the University of New Hampshire Law School for 15 years. Civil procedure is the course where lawyers learn the rules that govern the litigation of civil cases in state or federal court. And there's been a number of references over the course of the afternoon to the mandatory disclosure rules. Those rules actually started in the federal court. So as far as I know, it was the U.S. District Court rules that for the first time said, we're going to decide that each side has to disclose information about their case at the outset of the case or very early on at the case. And one of the things that the defense side needs to disclose is insurance policy limits. That was controversial because there was concern that, oh my gosh, if a plaintiff knows what the limits are, that's going to inflate the number that they'll demand from the insurance carrier in a pre-trial settlement or inflate the number they'd ask for at trial. That's been tested in the federal courts and in state courts. And I think the conclusion has been the full exchange of information, including information about insurance policy limits, actually leads to the efficient resolution of claims. And so just by the fact that the parties all know what the insurance policy limits are, everybody understands what the likely limits of recovery are. And there have been some concerns expressed about that, meaning you would inflate your numbers, as Bill Woodbury just described. You know, at the end, if you try a case, it's the jury who decides how much is going to be paid. And if you settle pre-trial, it's going to be the adjuster, the insurance company, who decides how much they're willing to pay. So the plaintiff can claim whatever they want. That doesn't mean that's what the plaintiff is going to get. So within the litigation process, the fact that policy limits are disclosed has not led to inflated demands, and it hasn't led to prolonged litigation. It actually facilitates the efficient, quick resolution of claims. And what this bill does, as I understand it, is just tries to move that to the pre-suit scenario when that's appropriate. And my thinking is that in most circumstances, that's actually going to be most appropriate in claims where the damages aren't very high. And it's to the injured person's benefit to know, okay, this driver only has $25,000 in insurance coverage. I've been out of work and have $30,000 in lost wages, but I'm never going to get more than $25,000 from them. So I'm not going to file suit. My attorney's going to negotiate a pre-suit settlement because we understand that the insurance potential recovery is limited. In high stakes cases, if it's a case where the liability is really clear, that driver was driving at 4 times the legal limit of intoxication and was driving the wrong way on 93 and did serious damage to this claimant, and you contact the insurance company pre-suit, that insurance company has the option of saving themselves all the litigation costs because you both understand it's a very strong liability claim and the damages are really significant. Now, the insurance company is not going to settle the claim because they've disclosed the policy limits. There's a whole opportunity once the policy limits have been disclosed for the attorney for the plaintiff and the attorney for the defendant or the insurance adjuster. Often they don't even get an attorney involved if what you're talking about is a pre-suit settlement negotiation. They exchange information. The adjuster says, send me the medical bills. They send the medical bills and they see if they can work it out pre-suit. So the idea is if you disclose this information pre-suit, which will be disclosed anyway if suit is filed, we're going to get the same benefits pre-suit that we get post-suit with the disclosure of insurance policy limits.
Okay, thank you for your testimony. Are there any questions? Senator Abbas.
Thank you, Madam Chair. And you can just, if you ever come across this, I know sometimes there are certain liens on a settlement, or, whether it's healthcare liens or whatnot, and sometimes those lien holders are willing to compromise that lien. In your experience, is it helpful for that lien holder to know what the insurance policy limit is, and perhaps if the limit's being paid, are they more inclined to negotiate a reduction of that lien?
Absolutely. And that goes both for private insurers where they have what's technically called a subrogation claim, not a lien. Medicare or Medicaid would have a lien. But in both instances, if the amount of insurance available, so your greatest recovery is severely limited, you would absolutely be making that argument is you should get paid back a little bit. The client should get paid a little bit for their harm. You know, we should equalize the fact that there's not enough insurance here to cover the real harm.
Thank you.
Any further questions? Senator Gannon?
Just to help me, no one else has to pay attention. I only got a B in civil procedure, sorry. In Senator Carson's example, would she be able to forum shop? Or would she, the cause of action, she mentioned an accident, if she was in Massachusetts, she'd have to take it there, right? She couldn't come back to.
She would have to take it there, but I believe a circumstance where a Massachusetts driver is traveling in New Hampshire and hits a New Hampshire driver and has a Massachusetts policy, New Hampshire lawyers representing the injured party just look at the police report, they find out who the insurance company is. They typically don't contact the errant driver, him or herself. They contact the insurance company. They say, I have a claimant here. Will you disclose the policy limits? And because that's the rule in Massachusetts, they just automatically do it. And I don't know what the crossover is, but my guess is that most of the companies that provide insurance in New Hampshire provide them in at least some of our neighboring New England states. So they're already doing it in cases that occur in those states.
Any further questions? Seeing none, thank you very much.
Thank you.
Okay, are there any other members of the public that would like to speak to Senate Bill 423? Okay, seeing none, we'll close the public hearing. Bill.
Yeah.
We're going to open the public hearing on Senate Bill 424 and recognize Senator Whitley.
Thank you, Madam Chair, and good afternoon again, members of the committee. For the record, my name is Becky Whitley, and I'm honored to serve New Hampshire Senate District 15, which includes the wonderful communities of Bow, Concord, Petticoat, and Hopkinton. So today I'm honored to introduce Senate Bill 424. This bill was developed in collaboration with the Department of Corrections, and it merely refines existing law by establishing a clearer framework for parole eligibility as intended by the legislature. So the law as it's currently written is vague and does not provide probation parole officers with legal direction on how to consistently consider parolees for a reduction of their maximum sentences. Additionally, individuals under administrative supervision are only seen once per year, and this bill creates an annual audit requirement for those cases. This type of policy was recommended by the SB 251 committee. This is the piece of legislation passed last year by this legislature, which established the study committee on the New Hampshire adult parole system, which I was grateful to chair. We met all summer. We heard from a number of stakeholders. It was a really robust conversation. We concluded our work and produced a comprehensive report of our findings. In our report, the committee recommended the development of clear and concise policy language and parole guidelines to provide greater structure when weighing or evaluating the factors associated with the decision to grant or deny parole. So this is not exactly in line, but very similar to the spirit of much of what the committee was looking at. So I appreciate your consideration of Senate Bill 424. I'm happy to take questions, but again, I will defer to the very capable folks behind me, including the folks from the Department of Corrections who can actually take you through how this really works. Thank you.
If you can introduce yourself for the record,
Yes.
be great. Thank you, Joe.
Hello, members of the committee. My name is Joseph Lascaz. I will be representing the ACLU of New Hampshire in support of this bill. I will also be testifying as a current New Hampshire parolee in support of this bill. SB 424 is a bill that came out of a report that was seen by the Council for State Governments that was outlining parole and community supervision conditions across the nation. And when we were able to settle on this particular piece of legislation, one of the things I really want to point out is that paragraph 1 is already what the current law is. So again, as Becky Whitley said, this is Senator Whitley. This is enshrining current legislation that the DOC has, which is something that should be done. Also, subsection B, though, however, this is really key. So when we look at what is included, education, employment, financial status, family, marital status, housing status, leisure skills, companions, substance use and abuse problems, other mental health needs and engagement with treatment, and thought patterns regarding criminal conduct. These are the foundational blocks for success in the community, getting a hold of those things. And so making sure that parolees now are this is being, I would say, scrutinized further to a higher degree. It creates an incentive on the parolee's part, right, to create good, positive patterns of behavior is really what this is doing. This is creating, I can't even think of the word right now that I'm trying to, habits, that's what it is. This will create positive habits by engaging in these activities. And the last thing that I wanted to say is under subsection B, part D says compliance by the parolee with parole conditions. What that does is, again, it puts the onus on the parolee to adhere to what the conditions of parole are, and that is what we want for people who are going to be under community supervision. And lastly, what this bill does is it makes it uniform across all parole departments. An individual could be on parole in one city or town and be on track, let's say, to potentially have his parole ended early through this process and then get transferred. And because this is not something that's currently uniform, that could kind of fall to the wayside, and it puts a greater burden on the parolee. This shifts that burden back to the state as the state making that responsibility, and I think that this is something that New Hampshire can really benefit from. I will end my testimony on that, and I'm happy to take any questions that anyone may have.
Thank you for your testimony. Seeing no questions, you have a great day. Good to see you again.
Thank you.
Helen Hanks.
Good afternoon, I almost called you Chairman, Senator. I'm definitely thinking about driving safely after listening to the last hearing, so I apologize. Let's switch gears and talk about parole. For the record, my name is Helen Hanks. I'm the Commissioner of the Department of Corrections, and I thank you for your time this afternoon. I appreciate Senator Whitley and the sponsors of Senate Bill 424. The culmination, I just want to be clear, of what's proposed before you is derived from departmental policy So we have it in our policy. It's just not prescribed in law. And I think that's important for our certified law enforcement, probation, and parole officers to understand that if Senate Bill 424, which I hope it does passes, then they'll have the support of the full legislature to understand the landscape of individuals that we want to consider to be put before the adult parole board. So just as a reminder, it is a process, but it still leaves the determination to the adult parole board and the court, accordingly to the other statutes that are referenced here. So this framework was recommended and affirmed through the work, as Senator Whitley already stated. I won't repeat that. But I do want to comment on the proposed new section, Roman numeral 1B. The reason also for those other areas is when you assess for recidivism, those are the key areas. So no matter what tool across the country, recidivism looks at those factors. And rather than cite a specific tool, I just wanted to cite those factors as commonplace in those assessment skills. The other part that I thought was very important is, although the current statute references restitution owed, I think it's important about what's been paid. So I incorporated that. And then it does reference victims, but I also wanted to make sure we talked about survivors of crime. And the other relevant factor, and I know you'll read my testimony, which is why I'm not citing it to you, is there are some exclusions that already exist in law. And that is in my testimony, because it does talk about individuals who are considered under RSA 504-A15, Tier 2, wrong reference, Tier 2 and Tier 3, it's under 651B1. I just want you to know it does recognize that in other sections of law, because other people may be asking, who does this include? And I know that's a common question. We have approximately 455 people under administrative supervision at this point. That's a lot of people, and it's very rarely used section of statute. And I do think it's because that our probation and parole officers need the support and confidence of, if they're going to shepherd people forward, who are those people? Let's have a layer of consistency, and let's try to be responsive to that. And then leverage our probation and parole officers' time and resources to the higher risk, higher need individuals under supervision. With that, I'm happy to answer any other questions, and I do appreciate your time and service to the state.
Thank you. Seeing, yes, Senator Abbas.
Thank you, Mr. Chairman. And thank you for taking my question. What occurs when someone's parole were to expire, whether it was reduced or not, but they still haven't paid the restitution?
Senator Abbas, that's a great question. It actually converts to a collection-only case. So the restitution is still owed. It just goes to a different area of the department and our collection-only area, and we will go after that restitution for the term of what they owe.
Well,
No, thank you.
You're welcome.
thank you. Seeing no other questions, you have a great day.
Thank you so much.
Does anyone else wish to testify on 424? Speak now or forever hold your peace. Thank you very much, everyone. That ends this hearing. What's that? Yeah, motion to adjourn? Oh. Yeah, we're just.